the buttons are.
Okay, okay, no issues.
Yeah.
Students, have you made our guest co-host?
Yes, ma'am. Ma'am, I'll make you the co-host also.
No issues. You need to be very visible, huh? When the proceedings are going on. At that time, there must not be any disturbance. Okay.
Right, ma'am.
I hope you have my PPT. The
Yes, ma'am.
PowerPoint presentation.
Yes, ma'am.
Yeah,
Yes,
I would need some assistance there. Yeah.
Right,
In
no problem,
changing
ma'am.
the slide. Yeah.
Right.
So I hope now you are able to see all the buttons on your system.
Yeah. So the two main ones, at least I can see, that is the mic and the video.
Okay, because we are not able to see you. So is your
Right,
camera
right.
off or on?
Just a second. Is it?
Yes.
Am
now-
I visible? Yeah.
Yes.
Yeah. Okay, great, great.
Because we are always comfortable in one-to-one. This online thing wherein cameras are off, we are required to take classes, but that satisfaction always come when we see.
That's true. That's true. And that too, in my assessment, is not the same. I mean, it's not comparable to offline classes at all. This virtual experience, it can never be.
It can never be. Yes,
Mm.
yes.
And in sessions like these, which is like supposed to be, interactive, this
Yes.
virtual thing actually becomes a killjoy at times.
Right, right. Obviously. It only serve a purpose, that is that we are engaging students meaningfully. That's the only purpose, which is going to be
That's
solved
true.
with online thing. But
Right.
receptivity and having on the same page by the speaker and by the attendees, for that matter, offline is the best option.
Right. Here, that entire connect is lost, as in you have to try doubly hard to create that connect and to ensure that, okay, you are being listened to and people are getting actually what you are trying to put across. So that's the reason why my PPT is also full of emojis, as you'll see.
Wow, that's great.
Yeah, I've tried to minimize the content on it. So it's as in each of the slide is not loaded
Yes,
in the
yes.
sense that it's like,
Right. Yes, I think now it's 9 o'clock, right? I
Yeah,
always
Yes,
keep my
ma'am.
9:05.
watch ahead. So
9:05.
therefore, so please let's start. Let's start.
Right.
With the
Anusha,
permission of our chief guest, please.
greetings of the day to one and all. We welcome you all to the second VIPS IPR National Workshop on Trademarks Law and Contemporary Issues, organized by the Center for Intellectual Property Rights, Vivekananda School of Law and Legal Studies, VIPS. We would like to take this opportunity to welcome our guest speaker for Technical Session 2, Dr. Sananda Bharti, Associate Professor, Law Center 1, Faculty of Law, University of Delhi. A very warm welcome to you, ma'am. I would also like to take this opportunity to welcome our Dean, Professor Dr. Rashmi Salpekar, VSLS VIPS. Vivekananda Institute of Professional Studies was established in the year 2000 by Dr. S.C. Vats, an educationist with a view to realize the words of Swami Vivekananda, man making, character building, and nation building. Vivekananda School of Law and Legal Studies is committed towards realizing these words of Swami Vivekananda. The Center for Intellectual Property Rights, VSLS, VIPS, organizing this two-day national virtual workshop in the memory of Professor Dr. Neeru Nakra, under whose aegis the center was established in the year 2020. The main aim of this workshop is to further the objective of the center to develop the intellectual leadership and capabilities in the field of intellectual property rights, and to examine and analyze the emerging trends in the field of trademark law. Without further ado, I would like to take this opportunity to introduce our guest speaker for the day, Dr. Sunanda Bharti. Ma'am is the Associate Professor at Law Center 1, Faculty of Law, University of Delhi, and possesses a wide experience in teaching intellectual property laws, arbitration, mediation, and negotiation, among others, at the university for over 16 years. Ma'am holds a BCom honors and LLM degree and has also completed her PhD in law, in addition to being a certified professional mediator. Ma'am was an editorial team leader with LexisNexis Butterworths India for 3 years prior to joining Delhi University as a faculty, thus fulfilling her dream of teaching law. She also has various publications to her name in prestigious journals and corporate legal magazines. She has been a pioneer in developing the jurisprudence on the legal personality of the fetus. It is a pleasure to have you amongst us as a speaker, ma'am. I would now request ma'am to please address the participants on the topic jurisprudential architecture of trademark. Over to you, ma'am.
Yeah, thank you very much for the introduction. It is actually my pleasure to be here with you, all of you today. As in, though I can't see all of you, but yes, I'll try and make that connect through my presentation today. Um, it's special for me. Why? Because Professor Neeru Nakra, late Professor Neeru Nakra, has had been my teacher, and of course, many of you would be knowing that tomorrow is her birthday. And yeah, she was one of the, you can say, the reasons why I was prompted to join, I was prompted to take up intellectual property as a subject, though she was not a teacher or for intellectual property for me. She taught me a different subject. So it is, let's see if I'm able to do justice to this subject and create a connect here with all of you. So without any delay, let me just, uh, can we have the presentation, please? Uh, can we have the slide?
Ma'am, the screen is visible. I mean, we've shared the screen. We
Okay,
hope it's
okay. It's
accessible.
not visible to me for some reason. Okay, yeah. As you can see, the title of my presentation is Registration of Trademarks, and I've tried to, uh, so it fits under the jurisprudential architecture of trademark. It is something very fundamental and very basic. Uh, with that, let me just start by saying that everyone present here is expected to know what registration of a trademark is, what are its benefits, etc., etc. So I'll go very succinct here, and let's start by Section 28 straight away. Section 28 of the Trademarks Act 1999, it talks about registration, talks about the rights conferred by registration. And subclause 1 there says, and I'm reading from the Bare Act, that subject to the other provisions of this act, the registration of a trademark shall, if valid, give to the registered proprietor of the trademark the exclusive right to use to the use of the trademark in relation to the goods or services in respect of which the trademark is registered, and to obtain relief of infringement of the trademark in the manner provided by this act. Now, slide 1, as you can see, two main benefits that you get through registration is that you get that wonderful certificate which you can show to anyone. So you actually get the right to show off, as might be visible in the slide. Yes. So you get the registration certificate which you can show to anyone who disputes your ownership over the mark. So registration has a strong evidentiary value. And the second right that you get is that you get the right to sue for infringement of your trademark. That means if anyone violates your statutory rights in that trademark, say uses a deceptively similar trademark in relation to same, similar, or at times even dissimilar goods or services, it might be a case of infringement. So these are the main benefits that flow from registration. And slide 2, please. This brings me to the first point that I would like to flag when it comes to registration jurisprudence, or rather the trademark jurisprudence as such, and that is that deceptive similarity, or this whole big concept of deceptive similarity or likelihood of confusion, on which the whole registration and infringement jurisprudence revolves. It is a very subjective phenomenon. You see, it depends on person to person. What might be confusing to me might be totally clear in somebody else's head. So sometimes this deceptive similarity business it's easy to discern, it's easy to gauge, but some other times it can lead to one party harassing the other or acting as a trademark bully. And it's when I say trademark bully, it's almost like saying that now that my trademark is registered and big, yeah, you dare not choose a trademark that is even remotely closer to it. um, and this results in one party, the big and mighty party, objecting to the other person's trademark, or objecting to getting or uh, allowing the other person, the other party, in getting that trademark registered by objecting to it for no reasonable or sound reason. And often we see the registry, the Indian Trademark Registry, succumbing to the rights, to the might of such big players. And the courts also sometimes end up doing the same. Uh, while deciding the concept of deceptive similarity, or while deciding this question of whether registration should be granted or refused. And I have two examples here which might be of interest to you. And slide 3, please. Slide 3, and just give me some moment, an opportunity to adjust my screen, because yeah. So what do you see on the screen? Can anybody tell me what you see on the screen? Who is she? Anybody, even anybody from the audience? Anybody from the faculty? Who is she?
Starbucks logo.
Yeah. So Starbucks logo. Yes, and this is not an Indian case which I have taken, which goes to underscore that the problem of defining what is deceptive similarity is perhaps universal, right? So this green lady, um, uh, modestly covering, if you have a close look at the icon, at the trademark logo, you'll realize that this she's green, of course, and she has long tresses, long hair. Uh, and actually, she's covering herself with her hair only, and wearing a very enigmatic smile. And the main reason why she's smiling is that she's trying to lure you into having coffee at Starbucks. And she is actually Siren. The name is Siren, right? Simply put, she is a mermaid with two tails, and you can see the two tails there. Why I'm telling you all this, because uh, um, uh, having a good look at the trademark is what is supposed to be done primarily to begin with, um, when one is to decide what is deceptive similarity, or whether a certain mark is deceptively, or whether there is a likelihood of confusion in the mind of that reasonable person of average intelligence, right? So now this Siren um, is Seattle is the hometown of Starbucks. This Siren comes from Seattle. Seattle is a port city having strong connections with navigation, with trade, and of course with coffee, which is still traded through waters. Now, and hence this device trademark of Starbucks makes it to be a good example of smart creativity, right? Now, this siren is popular, right? Because look at slide 4. Slide 4, please. Yeah, look at this. And what you see is the trademark of Mountains and Mermaids, because Mountains and Mermaids is another brand that is trading through Siren, right? And I've deliberately not put the two trademarks which I'm talking about, that is Starbucks and Mountains and Mermaids, side to side, as an adjacent to each other, because that is what we are not supposed to do. We are not supposed to keep the two marks side by side and then compare. So we are not supposed to do a minuscule comparison here. As per law, as per the case law also that has developed, right? Now, why we are doing this case law? Now, the reason is that the two proprietors, the proprietor of Starbucks and Mountains and Mermaid, they are fighting a battle over this mermaid, that is Siren, right? And what is Mountains and Mermaids? Mountains and Mermaids is actually a very small brand, small as compared to the mighty Starbucks, of course. And it is based out of Alaska. It is an apparel company, and it is clashing with Starbucks. And it uses so what does Mountains and Mermaids sell? What are the products? It primarily deals with, as it says, apparel. It deals with t-shirts and sweatshirts and coffee mugs. And of late, it has branched out into coffee also. And it has started using the expression Siren's Brew for its coffee and coffee products. Um, Starbucks had applied for a trademark Siren's Blend for its coffee. So it's Siren's Brew by Mountains and Mermaid, and Siren's Blend, and then this logo. And Starbucks wanted the US PTO, that is US Patent and Trademark Office, to reject this application by Mountains and Mermaids on the ground of confusing similarity. And their main objection is that the main objection, of course, is on the usage of the word siren and the accompanying logo, which they maintain. Starbucks claims that it is confusingly similar. In fact, they maintain that Starbucks has invested since 1971, ever since it started, it has invested so much into creating an association between siren and coffee, that anything to do with siren has to be linked with Starbucks. That is their claim, right? So they claim that whenever they see siren, they are likely to associate it with Starbucks. And now, whether this is confusing or not, I'll leave it to you. To me, the logos are not at all confusing. And I take it hence to be a classic example of a mighty registered trademark acting as a trademark bully. Yes, I would like to have some responses here. Do you see the confusion? Do you feel that And let's all be honest here. Is it confusing, the logo that you saw in slide 3 and this one in slide 4?
Not at all.
Yeah. So this is one of the what you can say, one of the aspects that I wanted to flag. I'm not, going into whether it is right or wrong. It is just that this is something in relation to registration of a trademark that we need to know. One trademark acting as a trademark bully and hence preventing the other from doing his honest business. Another example, of course, is the famous, or rather the infamous, Apple versus Pear controversy. Slide 5, please. Yes. So are they confusingly similar? What you see on the on their fruits, that's where the similarity starts and it ends. One is apple and the other one is pear. But Apple decided to take legal action against. It was quite a popular case, and many of you might be knowing it also, because it caught a lot of traction and a lot of limelight while in all sorts of media. Right. So Apple decided to take legal action against this company known as Prepare. Prepare is like an insignificantly small company as compared to Apple. And this is quite a recent case. Last year in August 2020, this happened. And why it happened? Because Prepare chose to have a pear-shaped logo as a trademark, which Apple claimed to be very similar to its own logo. That is Apple, that bitten apple, which you see on your screen. Now, what is Prepare? Prepare has nothing to do with technology at all, and in fact, it is a mobile app, right, which offers healthy recipes and a digital grocery list that goes with those recipes, right? And thankfully, Prepare showed some metal despite being small as compared to Apple. It showed some guts, if I may use that term, and it stood its ground. And when this whole controversy started gaining some traction in the relevant circles, Apple offered to negotiate, right? And and then we heard that both the parties had reached an agreement whereby Apple allowed Prepare to use that pear shaped logo, that fruit logo, with a subtle change, right? And if you focus on slide 6, please. This is the change. Here is the change, and you have to look closely to what the change is. Can you spot the change? Can anybody spot the change, please?
Ma'am, the leaf.
The leaf, yes. And this is a classic example, again, a very typical example of trademark bullying. And the point being that sometimes this aspect of confusing similarity is taken to the limit. And it happens more so when a trademark is registered, and trademark of the plaintiff is registered and reputed on top of that, right? So this is one point that I wanted to flag under trademark registration. Right. Slide 7, please. Yes. Slide 7 says first to use is almost always, it takes away the cake. First to use always wins in comparison to the one who's first to register the trademark, right? And the expression that I'm using is I've chosen the words very carefully, and you have to underscore it with you have to take it with a pinch of salt, in the sense that it is almost always. It is not necessarily. It is not a thumb rule. It depends on what policy the concerned country is following. We follow first to use. So first to use is gets its prior user rights over and above the person, usually over and above the one who's first to register a certain trademark. some other countries, say for instance, China is the first to file country. So the one who has filed for the registration of the trademark in the first instance has usually gets an upper hand over everybody else, right? And here I have again a very interesting case to share. Slide 8, please. On slide 8, you will see the Bentley logo. What is Bentley known for? Anybody? Again, a very popular brand.
Luxury cars, ma'am.
Yes, luxury cars. And uh, so this is the logo of Bentley. And whenever we talk about the strength of a prior user, we have to, I think, talk about this case, because again, it's a latest case. This established luxury car maker, renowned car brand, lost out to a clothes manufacturer in regard to the use of the word mark Bentley, right? As I said, not an Indian case, but very, very interesting nonetheless. Slide 9. Yeah. Now, Bentley clothing, it started trading in 1962, right? And Bentley clothing is very different from Bentley Motors. It has a different, insofar as the visual appearance is concerned, you can see the two chaps wearing, one of them is wearing a red t-shirt having the other Bentley logo, the Bentley clothing logo. Now, they have been trading under this trademark, trading for t-shirts, sweatshirts, and a variety of other, accessories, clothing accessories, since 1962. And whereas Bentley Motors, well, as the name itself suggests, and as the response also came, is a car maker, originally British, but now owned by Germany's Volkswagen. And additionally, however, if you just briefly can go back to slide 8, briefly, the other picture that you can see on the slide, the picture of a t-shirt, this what is the story behind this t-shirt? Additionally, so Bentley Motors, of course, is dealing with vehicles, but it also uses the word mark Bentley, as you can see on the screen, on its branded clothing, right? That is limitedly produced. It is produced in limited numbers. Why? Because it is only to be worn by the staff of Bentley Motors, the staff that is stationed at various dealerships and showrooms. And when Bentley Clothing objected to this, the court took notice, and the court said, yes, Bentley Clothing, insofar as the word mark Bentley is concerned, it has been using this mark consistently since 1962, and Bentley Clothing won the battle, right? And after this win, it would no longer be, the Bentley Motors would no longer be able to brand those clothes, at least, with the name Bentley. So insofar as the usage, slide 9 again, please. Insofar as the usage of the word Bentley on clothing is concerned, it goes in favor of the right is now with Bentley Clothing and not with Bentley Motors. And this goes to display quite aptly, in my opinion, the strength of a prior user, right? Why? Because Bentley Clothing were the first ones to use that trademark. Slide 10, please. Right. So slide 10 says trademark registration or usage, at least one should exist. And this is something very, very basic and fundamental. And in fact, it is one of the foundational pillars of trademark law. Almost across the globe, this is the situation. That one of the ways in which one gets rights in a trademark is through registration. That is, you get it registered and use it. But since registration is not mandatory, right? One may decide not to get a trademark registered, to keep it unregistered, and it's okay, but then you still got to use it, right? So you have to register and use, or yes, you can keep it unregistered, but still use it in relation to some goods or services and in course of trade. And this condition is the general principle. It has some exceptions. It can be relaxed. Say, for instance, in the context of well-known trademarks, as per section 11, it is relaxed, but then here we are talking about the general rule. And also it is relaxed at times by the court. And if I may put it, use the expression erroneously by the court, through cases like NR Dongre versus Whirlpool Corporation, that is 1998 Supreme Court case, which again many of you would be knowing about. And this is where the Indian registered trademark Whirlpool was allowed to be dislodged by a foreign trademark, because this was a time when Whirlpool washing, the famous Whirlpool washing machines, were not even available in India, and hence were not used in India. They were, however, However, to benefit this foreign trademark, the Indian Supreme Court coined a very fancy term. And the fancy term was trans-border reputation, that is TBR. So to say that that what if the trademark is not registered in India? So what if the proprietor is not supplying the Indian market and facing competition here? The name Whirlpool is recognized in India because it appears in magazines and journals and related media, right? So this was a new concept. Itself was, uh, was evolved or projected by the Indian Supreme Court just to favor the foreign trademark, and with the result that the Indian registered trademark Whirlpool had to go, right? Basically. So I've always maintained that NR Dongre versus Whirlpool Corporation is an infamous Supreme Court decision, which established that trans-border reputation of an unregistered foreign mark. And kindly note my words very carefully. Trans-border, it established that trans-border reputation of an unregistered foreign trademark not operating in this country was over and above a registered local mark, which I think was a very blatant and a bizarre thing to do. So I maintain, why bizarre? Because it goes against what the law reinforces or confirms. And I maintain what the law reinforces, that in order to get protected in India, your trademark should either be registered. You have to register it under the Indian Trademarks Act 1999 as per the law, and then use it. Or if you don't want to register it, it's okay. It's perfectly fine. Go ahead and keep it unregistered, but you have to still use it in course of trade in relation to some goods or services in India, that in the sense that you have to supply the Indian market and face competition here. You cannot just sit in the cozy comforts of your own place, just as Whirlpool was doing here, and dictate the how Indian law should operate here. Fine. So, and here again, something to extend my submission, we can learn from our neighbors here, right? And when I say neighbors, what I mean is China. Slide 11, please. Now, Chinese people differ in doing their business, in going about things when it comes to situations like NR Dongre versus Whirlpool, right? They differ because China is a first to file country, of course. First to file country because first to file in the sense that the one who is first to file for registration, as I explained earlier also, he is the one who takes the cake. Apart from that, uh, they differ in attitude also, right? The courts there would think twice before going against the local registered trademark. For after all, that local registered trademark is supplying their market and earning revenue for their country, right? And a mark such as Facebook, which you now see on, you might be wondering as to why this slide is showing, while I'm not talking at all about Facebook. So let me relate it to what I've said just now. Um, a mark such as Facebook lost to a Chinese doctor, right? Those who want to know the details, Dr. Su Kaiming, he is actually a dentist, a medical doctor. And it is common knowledge that that how did this happen? The story is that uh, many of you might be knowing. Actually, it is common knowledge that Facebook is blocked in China, um, and despite that, however, Facebook remains one of the countries that is China's top advertising platforms, right? And in this backdrop, uh, when in 2006, Dr. Su, who, as I said, is a doctor, doctor of medicine, right? Dr. Su, he filed an application for registering the trademark Facebook. It was allowed. And it was that Facebook was written in Mandarin, Chinese language, which you now see on your screen. So the first mark, first symbol in Chinese, it stands for face, and the other is book, right? So Facebook in Chinese would be written the way it is showing on your screen, right? So he applied for this trademark, and it was supposed to be in respect of, again, it's not nothing at all related to social media platforms, etc., etc. It's something totally different. Dr. Su's Facebook. It is in relation to computer software design, computer software maintenance, and creating and maintaining websites, the service of creating and maintaining websites for others. So he applied for registration, and when Zuckerberg's Facebook opposed, the Facebook that we know, the social media platform owned by Zuckerberg, when he opposed, he was told that, see, since you have not filed for registration in China, you otherwise also do not operate in China. So there is no reason why we should protect your Facebook in China. So and otherwise also, because you do not operate in China, you do not have any protectable reputation. So you better remain quiet, sit mum, right? And they did not consider trans-border reputation at all, right? So whether we have the inclination and the wherewithal and the guts to protect local registered trademarks is something that needs to be considered, in order to attach any weight to the registration process. Because if at the end of the day, our local trademarks, which are registered, which have followed the religiously followed the entire paraphernalia that is linked to registration, they have gone by the book, they have gotten it registered. If they are at the end of the day going to be shunted out unceremoniously, just as the way it happened in our Dongre versus Whirlpool Corporation, then we need to think on what is the relevance and what is the weight that we ourselves attach to this whole big story of registration of trademarks, right? So this is another thing, another aspect that I wanted to flag. Now, of course, there is uh, no compulsion, no need whatsoever to align your thoughts with what I'm trying to put across. But at the same time, I would want uh, to I think it is our bounden duty as teachers of IP to give you some food for thought, so that you are able to develop a certain standpoint, open up your thinking, horizons. And uh, yes, you need to think along these lines also on what is the treatment that is being meted out at times, what is the treatment that is meted out to Indian registered trademarks. And kindly note that this is not um, something that is uh, that is limited to China. This whole business of protecting local trademarks. The US, whom we consider to be a leader when it comes to trademarks or having reputed trademarks, is not far away at all. Slide 11, please. The US, yes, is not far away. The Belmora versus Bear Consumer. This is popularly known as the Flanax case, and it is going on. Actually, the litigation is still on. It has, I think, crossed just the appellate stage level, right? And here. Um, Let me not go into the details because it is going to I should leave something for you to research upon. It is about Flanax is a trademark for pain reliever tablet. It is right. And Bear, so we have two versions. One is Bear's Flanax, another is Belmora. Belmora is a very small pharmaceutical company as compared to Bear, but stationed in the US, based out of US, and it uses the expression Flanax, the trademark Flanax, in order to sell its medicine. Bear's Flanax is a very reputed, again, trademark. It might be registered it is based out of Mexico, basically. So it is primarily operating not in North America but in South America, that is Latin America, and it might be registered in 110 other countries, but it is not registered in the US. Belmora is. And Belmora is fighting tooth and nail with Bear in order to ensure that its registration of Flanax in the US holds against the might of Bear's Flanax. For details, as I said, I'm not dealing with the details right now, though I have it here with me, but I'm leaving it to you. Those who are interested can go and research and yes, educate yourselves. Next slide, please. Okay, slide 12. This is okay. Yeah. Slide territoriality and territoriality of trademarks and global markets. Now, on one hand, we say that trademarks are territorial in nature. That means that is something that what I had been discussing till now, which means that trademark would be protected if we understand it from the perspective of the Trademarks Act 1999. As I said, a trademark would be protected in India under the Trademarks Act, or the Trademarks Act 1999 would protect a certain trademark if it is registered in India, or if it is not registered, it is unregistered, no problem with it, but it should still be used in India in relation to some goods or services in course of trade, barring a few exceptions, say a well-known trademark. So this is the principle of territoriality. Now, how this principle of territoriality plays out in the real trade, right? Given the global reach of the internet now in the present day scenario, global reach of the internet, which has made cross-country availability of goods possible, is something that needs to be understood and accepted by brands now, by various trademark owners now. We are living in a globalized world. Everything, no sale can be considered local. If it is if the product is there on the grid, there online, available online, it is likely to be sold by sold and bought online, right? So due to the global nature of the internet, products are offered for sale online and can be viewed by a party stationed anywhere in the world, right? And likewise, from the seller's perspective, anyone present anywhere in the world who is connected to this whole internet web, right, to the grid, has the potential of supplying everywhere. And this makes the registration environment very tense and challenging, right? Because here there's a conflict of rights that is likely to happen, that is inevitable, rather not likely to happen, it is inevitable. Because where there are multiple owners of the same trademark, whether they are licensees or assignees operating in different countries, when owner one meant to supply only to country one, he tries to fulfill a customer demand made in country two, a different territory, a question arises as to whether it will amount to trademark infringement, or for how long uh, are we going to consider it to be problematic? Because this internet thing is for real. This global market phenomenon is going to stay, right? It's not going to go away. So, how we need to reconcile the two? On one hand, we have territoriality of trademarks. Trademarks are territorial in nature, and on the other hand, we have global markets. Fine. So this is also something uh, intrinsically linked with registration uh, that we need to understand. Slide 14, please. Next slide, please. Yes. So, time to touch upon something that I find to be very interesting, though it is not understood by many. And you might feel that as if I'm going back to the very fundamentals of yes, Tribo one. This Tribo one only. Uh, uh, to the fundamentals of trademark law as such. But despite being something very basic, it is not exactly understood by many, and that is that so many times even my students question me that you say IP is all about intellect. It is intellectual property that is protecting the creation of mind. Uh, and then we study trademark law. What has trademark got to do with creativity? I mean, we understand, that is what the students come and tell me. We understand that trademark is all about commerce, but how can it be linked to creativity at all, right? And it becomes at times a very interesting query to respond to, because to maintain that trademark law is a misfit. It typically should not fit under the IP umbrella, is not a correct you can say understanding, because though yes, primarily it has everything to do with commerce. Trademark has got to do everything with trade, but uh, uh, to say that it is totally divorced from intellectual creativity is wrong. A lot of work goes into creating a brand, creating a trademark, and at times this the originality of that trademark speaks for itself. And one example is here before you: creativity and trademark, right? Tribo. I hope it is you're familiar with the trademark. Uh, yes, one of you, some of you can respond. The trademark is familiar.
Yes, ma'am.
And what is it for? Yes. Anybody? What is Tribo for? Okay. So
hotels.
yes, budget hotels, economical accommodation. That is what Tribo is all about. So it's like Oyo, right? So guess what this trademark could mean? It's actually there on the slide. It's the Bodhi tree, reverse of that, reverse of that. So tree, Bodhi tree. And I loved the ethos behind choosing this or creating this trademark. And as the founders say, I quote, in many ways, these trees, the Bodhi tree, which is the national tree of India, right? Uh, in many ways, these trees were the earliest form of budget hotels, offering shelter to travelers without discriminating between the rich and the poor. And that is what prompted them to create this mark. So I find it to be a very unique example of where creativity and this intellect part of intellectual property is linked with trademark. Uh, and then there is this Unilever logo. Next slide, please. Next slide. Yes. Yeah. Unilever logo, again, a very, very popular trademark. This U, if you when this webinar is over and you get your leisure time, I would want each one of you to go through this Unilever logo and zoom out and focus on the icons that create this U, right? I think it is truly amazing. It is one of the most beautiful pieces of symbolism that I have come across till date. And see how apt it is. On the right hand side of your screen, you see each of the logo has been explained, right? And the story. So I'm always interested in the stories behind trademarks, and I do encourage my students to look for these stories and hunt for these stories in order to understand the trademark better, and consequently, yes, you'll end up understanding this whole business of trademark law better, right? So Unilever trades globally in almost everything under the sun that touches the lives of average consumers. So it is only fit that they chose to include a symbol for everything possible in their logo, right? And it truly boggles my mind to think that their products are used by uh, and this is as per a survey, as per a study, their products are used by 7 out of 10 people on this planet. 7 out of 10 people on this planet, imagine. Of course, the logo has been there since ages. So this is again creativity. I just wanted to break the monotony and the break the uh, too much of heavy duty stuff kind of tends to bore you at times. So I just wanted to break that, and so I decided to uh, use these two slides because they are informative and at the same time linked to registration also. So, and then we have names and trademarks. Can we use names as trademarks? Next slide, please. Next slide.
It's actually just taking a minute to load. We're changing the slide, but it's taking a minute.
Okay.
Minute, can you just try again?
Yeah. So can we register names as trademarks? The answer is yes. Why not? Can we get them registered? Yes, again, why not? Right. And what you see on the slide is something that this generation might not be familiar with, because after all, it is fountain pen ink. But Shell Park in my days was early days was a very was a must thing to have for a fountain pen user, Shell Park. And Shell Park resulted when Chelaram, uh, based out of South India, it he joined hands with the famous and mighty Parker. So it is Chell Park. Both are names, Chelaram Parker, and for short form of that is Shell Park. So an example of the fact that yes, we can register names as trademarks. And then next slide, please. Yes, this is Messi is the latest one in line. One of my favorites. I find the trademark to be really, really impressive. So footballer Messi, Lionel Messi, he succeeded in getting this trademark registered, but it was not an easy success for him because he had to fight a 9-year-old, 9-year battle for 9 years, right? He had to litigate with the defendant for 9 years in order to get his surname registered as a trademark in the European Union. Not an Indian case, it is registered in the European Union. Now, this Messi is supposed to what products does it stand for? Of course, it covers sports, clothing, gymnastics clothing, that is, footwear, and related equipment, and other analogous goods. Messi. So the defendant was the owner of a trademark, Massi, Massi. I do not have uh, the the picture to show you there, but it's simply a word mark, Massey. It does not have any device attached. The defendant's mark, the rival's mark, and this application of Messi was footballer Messi was opposed by Massey. Massey is a Spanish cycling company. On the basis of he said that, see, my trademark is also registered, and hence and this is phonetically very similar to that of mine. So you kindly disallow the registration. Kindly do not register Messi's the footballer Messi's trademark. And this is an interesting decision because both we are dealing with this with an already registered trademark, right? So the European Court of Justice, however, found the this Messi's international fame and reputation to be of more weight and substance, outweighing the phonetic similarities between the trademarks, right? So as you can see, things can हिंदी में एक कहावत है कि ऊंट किसी भी करवट बैठ सकता है. So when it comes to this is something that I wanted to, exactly the thing that I wanted to flag in my earlier when I started with telling you what how deceptive similarity is a subjective phenomenon when it comes to um, particularly in the context of registration. So this is when registration environment gets messy, right? uh, Anything can happen, and because there is a lot of subjectivity involved. Yeah, so next slide, time to deal with something again interesting. Yes, humor and trademarks. Humor and trademarks, what you see on the screen, I found it to be very, very amusing. um, so there was this in 2017 or 16, if I remember correctly, there was this meme that was doing rounds on the internet, and the meme was actually in relation to a Pakistani woman who was ranting on a news channel in Hindi using all sorts of expletives. So I've not included the video. It's not fit for general viewership. But then that meme resulted in this trademark, and the trademark says ye बिक gayi hai government. Yeah, and so all the information, it is an already registered trademark, so many of you might be wondering as to what is happening to the to the Indian trademark registry. But then, yes, humor and trademarks, I wanted to bring that bit out. Sometimes many of these trademarks, they tread a very thin line between being offensive and hurting somebody's sentiments and being outrightly humorous, right? But then the registry has to decide, and they do decide. And then next slide, please. Yes, I have 3 trademarks for you there. Um, one is so John Doe. Those who are familiar with John Doe orders or Ashok Kumar orders, John Doe has been registered as a trademark. Then there is one Hitler for certain goods and services, and then there is the first one that is there for you. And then we have just yesterday I came across Hi Rabba Murabba. Yeah. So that also is a registered trademark. So humor and trademark, yes, that's also possible. And that also is an example of creativity under trademarks. Next slide, please. Yes. Coming back to something serious, something much more relevant. Uh, we say that a trademark, upon registration, you get the exclusive right to use that particular trademark in relation to the goods and services for which you have gotten it registered, right? So in relation to some goods and services itself goes to prove that there have to be some goods and services with you which you would offer to the market, which you would want to supply the market with, right? And so in ordinary understanding, this implies that the proprietor of the trademark does have some goods and services, or it already is supplying the market with some goods and services in course of trade. And this is a very fundamental point in regard to trademark law as such, not only registration, trademark, important aspect of trademark usage as well as registration. But this aspect also seems to have been bypassed uh, by the trademark registry if the trend is to be of the registry is to be seen. Uh, and this that means we do have trademarks that do not stand for any goods or service and yet have been registered under the Trademarks Act 1999. For example, the Make in India mark. Make in India, kindly note that Make in India is a registered trademark, but yet, and you will find this mark on all the government websites, on all sorts of goods these days. But then those goods are not being produced under this mark. There are no goods and services provided by the government of India under this trademark. Instead, the mark is available upon prior approval from DIPP, that is Department of Industrial Promotion and Industrial, what is that? Industrial Policy and Promotion, right? DIP. So upon prior approval, you can use this trademark, and you can put it on any good manufactured in India or any service that is generated in India, catering to some or 25 sectors, manufacturing sectors operating in India. So it does not have goods and services of its own as such. And this was an initiative. Make in India was an initiative launched somewhere in 2014 to achieve a number of objectives. One was to say increase the growth rate of the manufacturing sector. Another was to create more jobs in the manufacturing economy, right? Then also to ensure that the manufacturing sector's contribution to the GDP is increased, right? And to achieve this, Make in India mark was launched. The idea was to encourage more and more foreign companies to manufacture their products in India. But their logo uh, is ends up performing functions not of a typical trademark, but of a certification mark. Again, something, but it's not registered as a certification mark under the Trademarks Act. Right? It is simply registered as a device mark. So this also sometimes makes me wonder, makes me curious as to, because it's a very curious registration. Um, uh, it makes me wonder as to what is happening with the trademark registry in India, because uh, yeah, so given this I just wanted to flag some of the situations so that you are able to relate to how things are and how things should be when it comes to registration. Okay, next slide, please. Okay, this is, yes, once you have gotten the trademark registered, that is not the end of the story. A trademark, unlike popular understanding with many, is not a right that is available with you till perpetuity. if you have gotten it registered. You have to constantly renew the registration. So initially you'll get the right to use that trademark. Exclusive right would be available with you for 10 years, and then after every 10 years, before the lapse of those 10 years, you have to renew it, and it is going to be available, the right with you in installments of 10 years. So long as you keep on renewing it, the trademark would be yours to use, of course. So trademark protection through registration does not exist till perpetuity in the true sense of the term, because it needs to be renewed every 10 years. And if the renewal process expires, uh, yes, the proprietor may apply for restoration, but this duration also, such requests can be made only within 6 months to 1 year after the expiry of registration. Beyond 1 year, the registrar would also be, would not be able to help you out, and your trademark is likely to be removed from the register. Another question that sometimes crops up is that, okay, once it is removed from the register, um, uh, uh, can you use a trademark again? The proprietor whose trademark it was, he can uh, get the trademark registered again in his name if any other business or enterprise does not use that trademark since its expiry. If it has been used, then he is unlikely to get his hands on that trademark again, the initial proprietor. Okay. So renewal is the reason why. Again, you might be wondering as to why I have this slide before you. Um, Renewal is the reason why some very old marks still rule the register and the world. And Coca-Cola is one such mark. Heinz for sauces and ketchups is another mark. Very, very old mark, 19th century marks, right? And insofar as the Indian condition is concerned, the first mark that you see on your left, the Temple mark, the Temple brand, registered in class 5, is the first registered trademark in India. And this information is not available on the data on the website of the Indian registry. But just to give you, just to attach some vibrancy to the slide, I included this information. It is no longer, it was not renewed. It was initially registered in 1942 for camphor by a British person. And when the Britishers left India, it basically fell into disuse and was not renewed, of course. Then trademark application 10, black and white, is still a vibrant functioning mark in India. These are one of the a few of the initial registrations under the Trademarks Act 1999, under the Indian Trademarks Act, right? So this slide is just to give you an idea as to what happens if you keep on renewing. It becomes a timeless household name and the trademark. And if you do not renew, of course, it is lost to times, the trademark. Okay. Next slide, please. Yes. To link this slide to the previous one, you are not supposed only to constantly renew the trademark after registration. You have to constantly use the trademark after registration, because almost across the globe, the trademark law, the registration bit of it at least, functions on this mantra or this motto: use it or lose it, right? And here, the car that you see is a Ferrari model, a Ferrari Grand Tourer class, and it is a shape trademark. Fine. And since Ferrari, now this is a very, very interesting story. This GT car, Grand Tourer Ferrari car, it is Ferrari 250 GTO, the model. It was produced by Ferrari from 1962 to 64. For only 2 or 3 odd years, he produced this model. And what is bewildering is that only 39 units of this model were produced by Ferrari between the stated years, and sold to individual buyers. So the owner was a bit of an eccentric person, and he sold it to individual buyers himself with um, 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 as in they were sold with the personal approval of Enzo Ferrari, the owner. And the design of this car is a registered shape trademark in the European Union. Fine. And it was recently cancelled. Why? Because as I said, 39 cars were produced from 1962 to 64. So since 64, no car of this shape has been produced. And when another proprietor, Ares Design, AERS Design, uh, it is also quite a nascent, young rookie auto company, and it presented its offer to before the authorities to develop a modern version of this car. And it maintained that since Ferrari had stopped making any car of this model, this 250 GTO cars were not being produced since 1964. The last model was 43 years ago. This shape trademark should be cancelled, which lies in favor of Ferrari, should be cancelled, and the European Union IP office it approved. So the only point that I'm trying to convey here is, no matter how big you are, you have to, post registering your trademark, you have to use it, otherwise you are going to lose it. Fine. So insofar as cars is concerned, vehicles are concerned, this shape cannot be used by Ferrari now. Okay, next slide, please. Just 2 more slides and then I'm through with the presentation. Again, something that we need to think about. This slide gives.
Excuse me, ma'am.
Yeah.
Dr. Sunanda, you please, if you can give some time for your question answers also.
Yeah.
That will be helpful for students.
Already
many questions are there. And after that, another resource person, he has already joined the meeting.
So, okay.
Kindly look
right.
Okay. Thank you. Please.
I'll just wrap up, by quickly telling you about this. This is Darjeeling tea trademark. It is a certification mark as well as a registered GI. And now, how is this possible? It is a very, again, curious situation, because all the time we maintain that dual protection is not available under intellectual property law. So again, what exactly is the registry doing about it? We do not know. Then next slide, please. Non-conventional marks registration. Non-conventional marks such as smell, taste, etc. They are not recognized in India, but we are opening up. The country has been opening up to at least sound marks in a fairly decent fashion. But again, the problem is that whether noise can be equated with sound is a question that comes to my head. And if we seek an answer from the registry, the answer seems to be a yes, because all sorts of when I say that we are opening up to these non-conventional trademarks, registering these non-conventional trademarks, we are opening up in a very big way. Anything to everything is being registered as a sound. Again, this research is not mine, but by a very wonderful friend, Akshay Ajay Kumar, advocate Akshay Ajay Kumar, and he has compiled this wonderful table, which clearly goes to show that even some sound that we would qualify as noise has been registered, and how they can be considered as distinctive is again a question that we need to ask ourselves. And also we need to consider as to what next is up. The sound of a pressure cooker whistle, sound of a door opening and shutting, can we even register these? So the jurisprudence is evolving and the registry is leading the way. And so next slide, please. Once registered, are we allowed to change the trademark? Yes, the answer is there on your on the screen. Myntra has changed. So the basic rule is that if it should not be a substantial significant change. Uh, if it is a substantial significant change, then you need to reapply. Otherwise, minor changes are possible. And Facebook, of course, is a substantial change. Next slide, please. Next slide. So this is Facebook into Meta. But how prudent is it for so Facebook needs to reapply, and it has already done that. Whether it is going to succeed in getting registration is a whole big question, because of the reason, and the reason is there before you on the slide. It is in my opinion not distinctive at all. In fact, all this Meta logo is so popular. I can think of Lenskart, which is not there on the slide. Cisco WebEx is again that meta infinity symbol. So the point was, yes, we are allowed to change the trademark, but it should not be a significant change, because otherwise you need to reapply. Then last slide, discrimination and trademark registration. The only point that I want to highlight here is that section 9, which talks of absolute grounds for refusal of registration, it should have one additional ground should be added, that a mark shall not be registered as a trademark if it is discriminatory in nature and is violative of Article 15 of the Constitution. Because Article 15 states that the state shall not discriminate against any citizen only on grounds of race, caste, religion, place of birth, sex, etc., etc. And the overall panorama surrounding skin color preferences in India is sufficient to indicate that darker skin color results in discrimination. So it is only fair that we add this ground also as an absolute ground for refusal of registration of a trademark, in order to ensure that the trademark registration environment, at least, is free from all sorts of discrimination. Yeah, I've used up, I think, 15 minutes extra, and I'm really sorry for that. But I hope you enjoyed this presentation. And yeah, I'm open to some questions, a few questions, if time permits.
Yes, definitely we will take questions, because students, they are really wanting to know many more things from you. I suggest to the comparers like Prableen or Prabhini, anyone.
Yes, ma'am.
Just to save some time, you read questions, okay? And
Right,
you may mix, because there are few questions, somehow they are asking the same question. So
right, ma'am.
You just do about it, okay? Yeah.
Ma'am, the first question that we have is the word Prime used by Amazon Prime. Is it a trademark word? And if not, could it be trademarked? Because they use the word in their ads, watch now with Prime.
Yeah. See, there are two things. Insofar as usage is concerned, one can use anything. Anything is possible. The more relevant question would be whether it can be registered, right? And to me, as a standalone word, prime is a very common word. It is unlikely to get registration. It is likely to be hit by one of the prohibitions of Section 9, absolute grounds for refusal of registration. As a composite mark, if there is other paraphernalia that goes along with prime, so there is logo, it is Amazon logo, and then prime, right? That can still be allowed, but with a disclaimer. So we have a very wonderful provision under trademark law, which says Section 17, which says the non-distinctive parts of a trademark are disclaimed. Nobody can have an exclusive right on those common expressions or common depictions. Yeah.
Ma'am, the next question is, the Eiffel Tower in Paris is a public property which does not hold trademark for its architectural design, but for its unique lighting. Would it be possible for people to get a trademark for that design itself, or the reasoning behind it?
Trademark for the design itself.
Right.
See, again, too many things all rolled in one. Perhaps the I might be wrong, but then to me, the person who has asked this question lacks clarity on what is a design, what is design law, what is protected under design law, what is um, the what is copyright, and what is the domain of trademark law. Insofar as trade getting a trademark on the shape of Eiffel Tower is concerned, I see a possibility, but it depends. So it is possible, in my opinion. Why not? Um, uh, it depends on lot many things, whether it is distinctive, and when we say distinctive, what are the goods and services for which that mark is being proposed to be used, and so on and so forth. Uh, for lighting. Uh, Lighting as such, I don't know how that trademark is going to look like, or to me it's kind of the whole business of lighting again. Somehow it makes my mind go more towards copyright law rather than
Trademark.
trademark law. Yeah.
Thank you so much, ma'am. Ma'am, the last question that we have is there a need for nations to have a common ruling principle when it comes to trademarks apart from Madrid Protocol?
Common, I didn't get that word.
Is there a need for nations to have a common ruling principle when it comes to trademarks apart from Madrid Protocol?
Common ruling principle. I would need a bit of more elaboration there as to what exactly the question is asking for. But um, insofar as my understanding, if I've understood the contours of the question properly, um, uniformity is always um, welcome, and uniformity is always, you can say, uh, needed in order to streamline things, right? So that uniformity is already being sufficiently taken care of by the Madrid Protocol. So in addition to that, that is again in my opinion, right? In addition to that, I see uh, I do not see a reason why we should have anything else over and above. At least in the current scenario, that is more than sufficient. That kind of
Right,
uniformity is already there, in my opinion. Yeah.
right, ma'am. Thank you so much. Ma'am, we would like to thank you for taking out time from your busy schedule and providing us with such an informative and a learning experience. We really hope to see you again really soon. Over to you, Anusha.
Thank you so
Thank you
much.
so
Yeah.
much, Dr. Sunanda. And I'm hopeful that very soon you will visit our law school and we would be having your live session.
Thank you so much, Professor
Yes,
Salpika. Thank you. Thank you for having me here. Yeah, I'm looking forward to that visit.
yes,
Yeah.
sure, please.
Thank you so much,
Thank you.
ma'am. I would request Dr. Dipali Vishisht, faculty convener, to kindly propose the vote of thanks.
A very warm and graceful morning to all, to our guest speaker, Dean Ma'am. I, Dr. Dipali Vashisht, on behalf of our entire VIPS family, may like to express my sincere gratitude to our esteemed guest speaker, Associate Professor Dr. Sunanda Bharti, for taking out time in the morning of this Sunday and enlightened us with her commendable session on jurisprudential architecture of trademark. Ma'am has covered very exhaustively many points: registration of trademark, unconventional trademarks, and the issue pertaining to the registration of trademark, specifically deceptive similarity point. Thank you so much, ma'am, for such a wonderful and informative session. I also want to thank our beloved Dean Ma'am, Professor Dr. Rashmi Salpekar, for constantly motivating and guiding Team CIPR, Center of Intellectual Property Rights. We are very thankful to you, ma'am, for your huge support and all the time. Thank you so much, ma'am. Prableen, over to you.
Yes, ma'am.
Yes. Thank you, Dr. Sunanda. And now let's welcome our new next resource person. He has joined the meeting, right?
Yes, ma'am. Sir,
Ma'am, I think Alka ma'am has also joined us.
Oh, wow, that's great. Good
Yeah.
morning, Professor Alka ma'am.
good morning, Anjan, sir.
Good
Yes.